going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. I've got a good one. It's a little bit of a longer one, but we're in front of Judge Goggins, and we have two attorneys that don't like each other. You know how we know they don't like each other? They tell us multiple times, and then the pettiness comes out. It's fun to watch. Well, from our angle, it is. If you're one of the parties involved, it's probably not so fun. But we have it's kind of a landlord-tenant case, but it's a restaurant, not a home. So no one's getting evicted. Someone's getting kicked out of a restaurant. At least that's what one of the attorney wants. Okay, let's watch it. Before I hit that play button, you know what to do. Hit the like and subscribe to your Jump Kick Backflips. Let's go.
Flushing Investments versus LL Restaurant, Inc.
Morning, Your Honor. Alex Benson on behalf of the plaintiff who's present with me today.
Mr. Benson, and do I have anybody with?
Yes,
Hello,
Your Honor. Yeah, Richard
Oh,
Sabo, attorney
Mr.
for.
Sabo.
Yes, how are you, sir? Attorney for Flushing Investment. For LL Restaurant, LL Inc. I think they're an Inc.
Got a lot of letters in there. What have the two of you talked at all?
No, Your Honor. I received a letter or an email saying that Mr. Sabo was out of town through April 7th. That was sent to me with a check that I assume was for the rent that was due on February 1st. So we returned that check because it was vastly past due. And there's really, unless they're going to voluntarily give up the tenancy, I don't think there's anything to talk about because they're way past due on that and they're way past due on the March 1st payment. We just want them gone. We've also had major problems there. I don't know if the court is aware, there was a major police incident there on March 17th. We just can't have them there. It's just that simple.
Unfortunately, Your Honor, yeah, there's a lot more to this, Your Honor. I found out via just checking the court records. My client is out of town and has been out of town, and he'll be returning about the same time I am, end of this week. I did send out I was able to get a good faith payment. I was dropped off from one of my client's employees. We did send a wire about a month ago that got returned. So yeah, there's a little more to this than that. And what I'd like the opportunity to do is to have the opportunity to get an answer in. Although I'm out of town, Your Honor, I can get that dictated into the court by tomorrow. A hearing next Tuesday, both my client and I would be available.
Your Honor, if I may, I mean, none of it really matters. His client was well aware of this because when we first sent him the notice to quit and a request for possession, he called my client, who we can swear in, and say, well, I'm in Georgia, I can't pay you now. And the lease, for clarity, this lease became effective January 1st. The first lease payment was paid only because it was deducted on a check that we were giving them. The February 1st payment was now paid apparently on March 25th when we're entitled to possession after 14 days. And the March 1st payment has not been made at all. And now we're on April 1st and that payment hasn't been made. Okay, the reason they want to continue this hearing is because they've already scheduled to have another party, much like the one they had on March 17th, where there was 20 or 30 police who had to come because of a shooting and gunplay that went on at the site. There's no reason for it. It's just subterfuge.
Your Honor, this is a non-payment of rent case. That's not true and all irrelevant. Again, there was a wire that my client testified that was sent. They got rejected, and then a payment was sent from my office, which would have had them current through March 31st, which apparently they now have rejected. I talked to my office this morning, and we have not received that check back. And again, Mr. Benson, I'm assuming is acknowledging that they did receive the 1 month. So, Your Honor, it was only 2 months. Your Honor, could you allow Mr. Benson? Could you allow me to speak? Your Honor, we have had a history with which Mr. Benson has not allowed me to finish the sentence. So I would just respect the request, let me finish. So, Your Honor, but for the return of the wire and the return of the payment, we would have been current through yesterday.
Your Honor, the problem with what Mr. Sabo is saying.
Hold on just a second, just a second, because the quite frankly, the easiest route for me is it was scheduled for today. How come your client's not here today, Mr. Sabo?
Your Honor, he's out of town, as am I.
Well, I understand, but it was scheduled for today. I've got nothing on the file that says, hey, we're requesting an adjournment. I got nothing. And for your sake, I don't, that's one thing, but he was supposed to be here.
And the only reason there was no service, Your Honor, on my client.
You accepted service.
I put an appearance in, and again,
You
Your Honor,
accepted service over a week ago.
Your Honor, the only reason that we even found out about this case is I searched the docket, and I did see that this was filed. This was on Wednesday. I left Thursday morning. So I put my appearance in for the court, and I asked Mr. Benson to send me the pleadings, which he did on Thursday. Again, my client's out. I have not had a chance to even review the pleadings. And again, Your Honor, I submitted a check, which is 1 month plus late fees, and a second payment was wired.
Your Honor, can I finally say something, because it keeps talking about this check he submitted? Evidently, Mr. Sabo's claim is the check that he submitted, which he's claiming made us current, was due on March 1st. There is a 14-day period under which he can send it, or we have a right to re-enter. The check is dated March 25th. It's 11 days late. It was sent to us. We received it on March 27th. I notified him at that point, we're not accepting it. It's way late. And this imaginary wire transfer thing, what does that have to do with anything? It's all just a story that doesn't add up to the reality. And the truth of the matter is, and my client will be sworn in if the court would like, and he'll confirm, the minute they were served and they received the notice to quit, they called him and said, we're in Georgia. We can't pay you. So it's all just a story. Let's take Mr. Sabo's at his word. And here's a copy of the check. It's dated 25th. It's 11 days after the period in time in which we're allowed to take the property back. So the mere fact that they sent it 11 days late, we never got a February payment, it's kind of a so what?
I do have, Mr. Sabo, I do have a proof of service in the file, so service by posting, March 27th.
Yeah, posting, that's correct. Yeah, I'm not disagreeing, there's a posting. But my client was not, again, my client was not there.
Okay,
So, but
if it was served by posting, though, why can't we proceed today?
Well, Your Honor, in that there's a posting, we should be afforded the second hearing. There was no personal service.
This is a corporation, though.
I don't disagree with you, Your Honor, but just again, my client was not in town. It got posted, so my client he hasn't seen any of these documents. He's back, my understanding, the same date I'm back on Friday. So
and present by Zoom, just like Mr. Sabo is.
Yeah,
again,
I do find it's a little bit, not from you, Mr. Sabo, but it's a little disingenuous to have your client not here at all when I make it real easy for everybody to come on to at least tell me, hey, listen, I'm out of town, I can't do anything. He isn't even here.
Okay, I do understand, Your Honor, and the good faith was I told him have someone get a check, get it in my office, sent it. So again, there's good faith that he has a check in his hand for. There's only 2 months delinquent, Your Honor. He has a check for one of the two, plus late fee.
We have a lease that specifically says if they don't pay within 14 days, We get the property back. So what is good? I don't understand what good faith means. Why sign a lease or have the language if it's not enforced?
Okay. Tell you what, I've got one or two more similar, at least just single files. I'll pass on this for a few minutes, Mr. Sabo. If you can get your client on the Zoom here, I'll let you plead with me a little bit. But right now, I'm going to quite
All right,
frankly.
thank you, Art.
proceed,
Yep,
so.
yep. I'll try my best. Thank you.
Okay. All right. All right, Mr. Benson, just hang in there. We'll pass on for just a few minutes. Okay.
Yes, Your Honor. Thank you.
Sure.
All right. So you kind of get the basis of what's going on. We have a landlord who decides to go on vacation instead of a tenant court, apparently, and that he's behind in rent. Well, the owner wants the property back. He's behind on rent. He wants the property back. It's kind of interesting removing a restaurant when they're behind on rent, even though they're trying to pay. Yeah, that's not something you can do overnight. So I know how this turns out. I was gonna say I'm interested to see how this turns out. I'm interested to see your guys' comments when find out what happens.
Let's see. Nobody's interrupting me with Flushing Investments yet. Looks like did Ella Restaurant, Mr. Sabo, did you get a
Your
hold
Honor,
of
yes, my client indicated
I'm sorry?
that he is in the waiting room looking to get admitted. That was his text to me 4 minutes ago.
Okay, I let everybody in that was out there right now. I got nobody else. What's your client's name there?
Are you there, Gus?
I'm sorry?
I'm looking to see if he's answering.
Oh, but there I got another one just popped in, an iPhone 2. Maybe that's it. Looking for anybody with the LL restaurant?
Yes, sir. I'm here.
Oh,
that's it.
iPhone 2. Yeah.
There we go. Got it. Thank you, Your Honor.
Okay. LL. Okay.
Sorry. I just want I don't want no kids or nothing walking in on us in the background. Sorry about that.
Okay. Well, I'm ready to, I guess, proceed to a point today. Mr. Benson's here. Mr. Benson, do you have a witness here as well, you said? I thought you did.
Yes, I do. I have Mr. Jonah.
Mr. Jonah, okay. Mr. Sabo, are you ready to proceed as well?
Well, Your Honor, again, I'd like the opportunity to submit to the court. I'm not going to be able to have unless you'll take testimony from my client that he did wire a payment last month. But again, I would like to be able to present that and get verifiable proof to you.
Your Honor, may I respond to that very briefly?
Sure, sure.
There was a payment. We don't dispute that he sought to wire a payment, but it was 20 some days after the 14-day period, and as a result, we rejected it.
Okay, and if that's this, if you can, I guess we can go through the proofs. If there's a stipulation that maybe, if you're not going to object that you maybe received a wired thing after, we can do timeframes, I guess, for everybody.
And just like we admit that a check was sent to us dated March 25th from Mr. Sabo's office that we returned, that was 11 days past the March date.
Okay, so let's go ahead and proceed, and then I'll let everybody object to whatever they want to object to. Mr. Benson, why don't you get your witness there? Who's your witness?
My witness is right here. He's the owner of Flushing Investments, Mr. Jonash. Can you state your full name and business address for the record?
Zev Jonai.
Okay, I can hear him. Yep. Why doesn't he raise his right hand there for me? Sir, do you swear from the testimony you're about to give will be the truth?
Yes.
Okay. Mr. Benson, you can go ahead.
You are the principal of Flushing Investments?
Yes.
You are also party to an amendment to a lease recently signed by the parties?
Yes.
You understand that pursuant to that lease, they must pay the rent on the first of each month, and that rent was $7,500 a month, correct?
Yes.
Did you ever receive a wire transfer for the month due February 1st?
Yes.
Was it after 14 days or after February 14th?
Yes.
Okay, and did you return it as a result of it being beyond the 14-day default period that is set forth in the party signed lease in paragraph 5A on page 3 of the lease?
Yes.
So you sent it back, right?
Yes.
Okay. Did you subsequently ever get a check, cash, any other payment for that February 1st payment?
No.
You're aware that I received at my office, sent from Mr. Sabo's office, a certified check that was dated March 25th, and it was sent by priority mail that same day and received in my office on March 26th.
Yes.
You are aware that that is 12 days past the 14-day default period as set forth in the lease as I've described, correct?
Correct.
Did you instruct me to send the check back to Mr. Sabo?
Correct.
Okay. Since January, have you received any timely payments of rent?
No.
Today is April 1st. Did you receive a rent payment for April 1st?
No.
So as we sit here 3 months past due in rent,
Correct.
February and March, did you receive any payments in the first 14 days of either of those months?
No.
Okay. And if you received a wire transfer, it was well past that 14th day?
Correct. It's a.
Do you have the date?
I believe so right here. Don't quote me. It's right. I think it was on March 3rd. Is this March 3rd? Check it out.
March 3rd is when they wired you. Okay. So March 3rd would be 30, well, it's the 28th, and that would be 31 days past the due date of February 1st, correct?
Correct.
And then it would be another 17 days past the default period.
Correct.
Okay. Your Honor, do you have any further questions for my client?
Mr. Sabo, Mr. Sabo?
Yes,
questions?
yes, absolutely. At any time, did you declare the lease terminated?
Yes. I mean, he doesn't know, but we sent
No,
just
that's a question.
Hold on.
well,
That's not a question for Attorney Benson.
well, he doesn't know what we sent out, but okay.
Your Honor, he's
Let-
testifying.
Yeah, I know, Mr. Sabo. Let's let the witness
Okay.
answer.
Did you ever declare terminate?
What are you saying now?
Well,
Your Honor,
so you
I'm
can't
asking.
coach him. Hold on,
Yeah, I
yeah,
forgot
you
to
can't coach him.
get it.
If he doesn't know, he doesn't know, he can say that, but he's got it, no coaching.
I'm not answering.
Okay, yeah, no, I know, I'm just
Okay.
telling him. Yeah.
Again,
Mr.
sir,
Sabo, go ahead and ask again.
was the lease, did you ever declare that the lease was terminated?
I can't answer that because I know you're supposed to pay me every first. That was the lease that I was aware of it. You gotta pay me every first. It can be late a few days, but not to be late 2-3 months or something like that.
Okay, I'll take that as a no. Your Honor, no further questions.
And go ahead, Mr. Benson, any redirect with your client?
Sure. Zeb, did you instruct me to follow up with the law to remove him?
Yes, I did.
Okay. You're aware that I sent out a demand for possession that was served on February 19th of 2025. Okay. Thank you. No further questions.
Mr. Benson, any other witnesses?
No, Your Honor.
Okay, Mr. Sabo, any witnesses on your side?
No, Your Honor, the fact that they've indicated they've acknowledged both receipts and that they did not declare the lease terminated, Your Honor, we will stand on those proofs.
Okay, I'll give both of you a chance to give just a brief argument, Mr. Benson.
Your Honor, just for out of order a little bit, we actually obviously did demand possession under the lease. And as the court knows, monies that are due to us is a different lawsuit than demand for possession. Demand for possession was made and not disputed on February 19th, and it was served on them and they received it. We filed the proof of service accordingly. They made or attempted to make the February lease payment, which was due on the 1st of the month, and certainly to be paid no later than February 13th or 14th. They attempted to make that payment on March 3rd, some 17 days past the default period. That's not in dispute. He had an opportunity to dispute it. It's not disputed. So they defaulted under the lease in February as of February 15th. They then made or sought to make another payment on March 26th by sending us a certified check dated March 25th. It is not in dispute that that was 11 days after the default period. So giving the defendant the light most favorable, they were still in default on both efforts to make payments by 2 weeks on each one of them. So they're in non-compliance with the lease. The language of the amendment that was signed and took effect January 5th was draconian on purpose. We knew who we were dealing with. And it said that we shall be able to take possession if they don't pay within 14 days. They have now violated that 2 times without dispute. The defendant actually reached out to my client at one time, said, I can't pay, I'm in Georgia. And he was aware that we had filed the notice to take possession. He was aware that we had filed the landlord-tenant action. And there's really nothing to say. They violated the terms of the lease, and we want them out.
Mr. Sabo, anything?
Yes, although they do want them out as background, my client just reopened this establishment, so we do admit we were a little late and past 14 days. However, the lease does require them to declare the lease terminated. They have not done that, and by virtue of that, both payments that were sent, although late, would still constitute a payment in full, and they both were paid on or before March 31st, which is the date by which both those payments would not be in default, meaning there's no further payments due. So they were paid in full, but for them returning these checks March 31st, Your Honor.
Mr. Sabo, can you point me to
Absolutely.
something in the
Yes, yep,
lease or
yep,
the
yes,
amendment
yep,
that says they
In
must
number
declare
five
hold on.
default.
All I want is something that shows must declare terminated.
Right there. Yep. Go to 5A.
Okay, on the lease or the amendment?
The
part?
amendment. The amendment.
Okay.
Halfway down, Your Honor.
Okay, I got it. Right to re-enter.
Yep.
Okay.
That's the paragraph he's relying for the 14 days. And then we're relying on, which would be line 1, 2, 3, 4, 5, 6, the 7th line.
Your Honor, I believe my February 19th letter that attaches on
Your Honor.
top.
Oh, hold on, Mr. Benson. I'll give you a
Certainly.
chance. Hold on.
Okay, sorry.
Let Mr. Sabo finish first.
Yeah, I thought he was. I'm sorry.
So, yeah, okay. So Mr. Sabo, just so I understand, it's 5A that you want me to review for what you're arguing about as far as must declare
Correct.
to be
Yes.
terminated. Okay.
And we have had
Right, I'll look
no declaration that the lease is terminated.
Okay, so I'll look at that. And Mr. Benson, what did you want me to look at here as far as the lease for?
Your Honor, we're in the same place. I would just say
Okay.
that on February 19th, we sent a letter that said, enclosed, please find demand for possession, non-payment of rent, landlord tenant with regarding to outstanding rent owed to Flushing. Please pay immediately or eviction proceedings will be taken. I don't know how that doesn't qualify for the language of 5A. We're telling them that they haven't paid rent, and we're telling them that we're going to evict them pursuant to the lease. So I mean, they signed the lease, they understand the terms of it.
Wait, do I have a copy? Apologies. Do I have a copy of that letter? It's kind of a notice to quit letter. Where is that? Where is that at, Mr. Benson? Do I have that somewhere?
Well, it was fine. Let me just see, Your Honor. I believe it was attached. If it wasn't, I can obviously forward it to the court. If the court would give us a few minutes, I could send it to you.
I may have, maybe I've got it. Yeah, maybe I've got it here. Are you referring to the demand for possession of non-payment of rent? Is that
Yeah.
what I'm looking at?
Yep. And then there was a letter attached to it.
And then there's a letter.
Yep.
Oh, oh, wait a minute. No, the only thing I got beyond.
Yeah,
got
you don't
the,
have you don't have the letter. You have the demand for possession that went with it, Your Honor.
Yep, I've got that. Okay, I just don't have the letter.
You don't have the cover letter because I didn't think that I would.
Okay,
I
so
didn't- yeah,
is
but
there
I don't
any
think they
reason?
dispute there's a cover. I don't. I would be shocked if they disputed the letter.
Okay. Okay, so you're telling me though I can rely on the demand for possession as far as your argument?
100%.
Okay. Okay. All right, well, both of you give me 1 minute. I'll review the documents I have in the file here, and I'll come right back on it.
Thank you, Your Honor.
All right,
Thank you, Your Honor.
sure, sure.
All right, good time for a break. So, Judge is going to review the documents, like he just said. What do you guys think? I mean, the guy hasn't paid rent. Oh, I'm fast forwarding now. Yeah, you're welcome.
And may remove all purchase or performed by tenant after making it. I'm here.
All right, we're about to start again. Yeah, so the guy hasn't paid rent. They have the owner has the right to possession of the property. Yeah, just like a regular landlord tenant involving an apartment or a house. Seems pretty straightforward to me. I just love how you can tell that attorneys do not like each other. They probably see each other a lot, I'm guessing. Also, for the owner's sitting behind the attorney, and when the attorney was questioning him, he didn't even turn around. It looked like he was questioning us, but the owner was responding. It was a little weird, a little awkward. All right, let's finish this one up.
And we can go back on the record with Flushing Investments LLC versus LL Restaurant. Got the attorneys back on here. There we go. Mr. Sabo and Mr. Benson had a chance to review the documents and pleadings in this matter. I have a chance to review the demand for possession that was dated February 19, 2025, according to the form. Also the commercial lease agreement itself and the First Amendment of lease that is entitled. That was dated, it looks like, on here it's blank at the top, blank day of December 2024, but there's been no dispute that this is a executed document between the parties, their signatures that appear at the back of the amended lease agreement. Also attached. It's in the body of the lease agreement, though. Landlord and tenant did hereafter make and enter into a certain commercial lease dated January 1st, 2024, covering premises at, and it's the restaurant location on Pearson Road that both parties have argued about. Do find based upon terms under the default, paragraph 5 defaults, it says under 5 subparagraph A, right to re-enter in the event of any failure of tenant to pay any rental or other charges due hereunder within 14 days after the same shall be due. And this is what's important for me. Same shall be due, comma, or any failure to perform any other of the terms, conditions, or covenants of this lease to be observed or performed by tenant for more than 14 days, and there's no comma after this, 14 days after written notice of such default shall have been mailed to tenant, comma, or if tenant shall abandon said premises or permit, then goes on from there. In reading that paragraph in its totality, the intentions of the written document itself, it separates it into 3 possible default violations. And the first is very particular. It says, again, any failure to pay any rent or other charges due hereunder within 14 days after the same shall be due. That's the important part. There's, at that point, you go down to the right to terminate this lease. Back down further in that paragraph, it says, if tenant shall, well, let's see, where is it here?
I think you're talking about the next sentence.
It says further in the body of that paragraph 5A, and it's referring to the landlord shall have the right to declare this lease terminated and the term ended, and or shall have the immediate right of reentry and may remove all persons and property from the demised premises. And then it goes on from there. If I read that paragraph in its totality, if it's very clear that within 14 days, if that rent isn't paid, then the landlord has a right to terminate that lease agreement. I understand the arguments with regard to notice, but the way this is written, it's very distinct with commas and separates those out into different defaults. There's also been noted that there was a demand for possession of non-payment of rent that has been executed and supplied with the summons and complaint as well. I've heard testimony with regard to several late payments on rental checks. Both sides acknowledged that rent was late on several occasions, actually more than well over 14 days in its totality. Therefore, I do find that the plaintiff does have a right to terminate this lease and demand possession of the property at this time.
Your
Thank you,
Honor,
Therefore,
Your Honor, if I may
Mr.
ask,
Benson, what would you like me to do as far as what's going on with that?
Well, we'd like to lock
ruling
the
as far as
doors.
what's
We'd like
owed
to,
and
uh,
possession? Can
we'll
you give me some
probably,
time to move?
we would really like to lock the doors and
Whoop,
follow
I'm
the.
sorry, I'm sorry, I had you off there. I had too many people. So go ahead. I'm sorry. Go ahead.
We would like to adhere to the language of 5A that lets us hold their property for them and remove their property and store it. We don't want them back in there at all. So we would like to have the doors locked today.
Okay. Mr. Sabo?
Your Honor, two things, just for appeal purposes, can you
Yep.
indicate what plaintiff has done to declare the lease terminated?
What I'm telling you is, the payments were late. It was after 14 days, and I just recited that paragraph. It says, if it's not paid within that 14 days period. Yeah, I
Just
know.
trying to confirm that they
Within-
don't have to do, in your opinion, they don't have to actually do anything affirmative to terminate this.
It's a typical lease agreement, and it's very clear that if it's not paid within 14 days, they have a right to terminate that lease. And I just was very precise with regard to where those commas are and where those periods are. What you're asking for me to do is they've got to declare a termination. I'm telling you, they did their declaration on that possession of.
Okay, perfect. That's all I asked, Your
people.
Honor. So
Yeah,
the demand for
I know.
possession, the
So-
demand for
That's what
possession
I'm relying.
constitutes the lease termination.
So
Yep.
I just need that for perfect. And then obviously by law, we at least have 10 days with which to remove our belongings.
actually, the lease doesn't say that. It says alternative to that, Your Honor.
Well, I would normally does it say somewhere in here? I didn't go that far with regard to possession of their property. I understand
Your-
that I don't mind the safeguarding it, and I understand they don't want them on there anymore because of all the problems they've had. But Mr. Sable, what are you asking me to do?
I'm
with
asking you at least
property?
10 days, Your Honor. I mean, we have
Yeah.
a personal property. That's more than reasonable.
Yeah. Mr. Benson, they're asking for 10 days to get their property.
Well, our concern is damage that'll occur. So what I'm suggesting is following. The lease specifically says that we are entitled to, upon reentry, so which would be, today, remove all persons and property from the demised premises, and such property be removed and stored in a public warehouse or elsewhere at the cost of the tenant, without evidence of notice or resort or legal process, without being deemed guilty of trespass or becoming liable. So under the lease that they signed, we're allowed to do just what we're asking for. What I would recommend, excuse me, Mr. Sabo, I see you want to talk, just hold off. What I am willing to do is let us lock the doors, and then we'll accommodate them on when they want to come take their property. And we want to be there to see what they take and don't take, because we have a very strong belief they'll destroy the contents of the building.
In your Honor, we do have a right to appeal as well, which that will be done. So for your Honor, I mean, at least, I mean, a 10-day period is a very, very short period of time with which to remove all belongings from a commercial restaurant and a banquet facility.
So
they're trying to extend the time so they can have another party there, Judge.
Mr. Benson, I'm speaking, please. And again, we have the right to, and I respect your Honor. I've been in front of your Honor hundreds of times. I respectfully disagree
Sure,
with again with what you deem terminating the lease. But again,
Sure.
that's we have a right, and we will seek those. So we do have the right to appeal, and I would at least like that period of time to get the appeal filed.
So I guess, Ms. Sabo, I'm just trying to make sure I understand what you want me to do at this point. If you want your client to be able to come in to take property out, or are you asking me just to make sure it's safeguarded? What do you?
No, I'm asking for just for a right for 10 days. And again, this was from my understanding, this was a non-payment of rent case. So what form of judgment is there going to be? Because again, this was a demand for possession for non-payment of rent. So we have a period of time with which to cure that, typically speaking as well. So again, we get the form of the judgment, but you're a minimum 10 days with which to remove pending the filing of the appeal.
Couple things, Your Honor. We don't want them there. I know that their intent is to have another party. We can't have them there, given all the circumstances. And the lease specifically calls for immediate possession. So we won't, what I'm saying is we'll lock the doors and keep them locked and safeguard their property until if they want to take their appeal or whatever they want to do. We just don't want them in there.
Yeah, I understand. What property, I guess, Mr. Sabo, for me, I agree with what Mr. Benson's telling me. And quite frankly, to safeguard the premises itself, I understand that part of it. And the lease, the way it's written, it's pretty clear. As far as I'm concerned, they've got immediate right of reentry and possession of the property. Now, I wouldn't agree with that if they're going to take the property and put it out to the curb or anything, but they're talking about locking the doors and safeguarding it. If there's things that they want out of there immediately, I guess we can work through that part of it. But if it's just safeguarding things, that's entirely different.
And I'm also asking where in the complaint is pled for immediate possession.
Paragraph 5A says that.
Yeah, it's right at the bottom of the paragraph there.
Yeah.
It says, No,
Your Honor, I mean in the pleadings, Your Honor, not in the because this is a standard non-payment of rent case without alternate remedies requested.
It's a standard demand for possession case.
Correct.
Right. We're past that hurdle. We're offering to safeguard the property, lock it up pending whatever they want to do for a period of time. We just don't want them
at least a few days, Your Honor. At a minimum, a few days to be able to get our possessions out. Minimum.
We'll make arrangements to do that with them. As I said, Your Honor, we want the police there, and we want to be there.
Okay, now it sounds like you both are at least talking the same way as far as getting the items out. Can we pick a date and be over there to have them move things out?
Sure.
Why don't we just pick a date, Mr. Sabo? When and I'm talking about, I'm not saying that it all has a particular date, but there's specific things they want out within this time period. If you're going to appeal it or whatever you're going to do, this 10-day period, are there certain things that they want out? right
Yeah,
now?
and again, yeah, I have to again, I have not had really talked to my client about how long it would take to get things out and the like. But I mean, this seems very extreme in order
Yeah,
to
sure. And I
uh,
understand, but the contract's extreme. And again, we got our difference of opinions. I understand.
agree.
But what if we can pick a date and say, okay, this is the date we're gonna have, at least we're gonna go over, everybody's gonna go over, they're gonna be allowed to take out items out on this date. And then anything else left, I'm gonna tell Mr. Benson, same thing, they gotta be safeguarded until there's whatever's happening, appeal or whatever, if that period runs.
I
Okay?
mean, I would assume, Your Honor, we would at least, like, I haven't been able to speak to my client about any of this. So, I mean, a couple of weeks is a minimum that we'd be able to have to get. I mean, he's not even back in town until later this week.
Mr. Benson, can we pick a date later, I guess?
It seems, I mean, let me just ask Zeb, how long, I mean, can we do within 21 days? Is that good?
21.
Yeah. I mean, we'll agree to something within 21 days. We'll lock it up today. They'll reach out to us and
Okay.
we'll make arrangements to have the proper people there when they come to remove what they're going to remove.
Okay. Why don't I do this? Because I'm spend a lot of time with the two of you on this part of it. You understand my order that I'm granting judgment for them. Mr. Benson, I guess what I'll need is an order for that. And I know, Mr. Sabo, if you're going to appeal it, obviously you got a right to an appeal.
Yes.
If you could get the two of you together to work out details on the property part of it. And if not, I can do it later on today or later on this week, whatever you need, if you can't reach some kind of agreement with property.
Okay,
Does that make sense?
I'm around all day. I can draft a proposed order and email it to
Yeah,
Mr. Sabo.
yeah, and I'm not. You know, I mean, I'm on
Oh, you're
vacation.
out of
Yeah, I'm on
state,
vacation. Yeah, I'm
yeah.
taking this whole morning away. So,
Sorry.
um,
Oh man, I remember those days.
yeah, fun stuff. Yeah, and Your Honor, Mr. Benson and I, we've had a long history, and let's just say it has never been pleasant working with him, and he will say the same thing with me. So, we can agree on one thing. So, if we could just agree on a 21-day period, I thought he said that to his client.
Okay. Is that can we do that, Mr. Benson? 21 days.
I'll let the insults roll off my back, Your Honor, and let my legal work speak for itself. I would point out that the draconian lease was Mr. Sabo was on the other side of the negotiations of it, so there's nothing new or surprising to him. I will say this: I'll draft a proposed order with 21 days in it. I'll say that we have possession effective today, and that we will provide an agreed upon day or dates for them to take possession of their property.
Yeah. Okay, if you would do that for me, and then I guess why don't we do this? Hopefully you guys can reach some kind of let's do it under some kind of 7-day order, I
Perfect.
guess.
That's what I'll do.
Then there's
That's
an
what I'll do.
objection. We'll deal with it then.
That's
too.
what I'll do. That'll make things easier.
Thank you, Your Honor.
So yep, and in that just put the whole, Mr. Benson, just for my sake, do the whole judgment so Mr. Sabo knows what he's dealing with.
Yep.
And the whole thing, okay?
And I will prepare all that, and I will email it to him today as well, Your Honor.
Okay. All right,
Okay.
guys.
Thank you, Your Honor.
All right.
Thank you.
Thanks. Yep. Bye now.
All right, that's it. What do you guys think? I told you. I really just like these attorneys going at each other. I found it entertaining. I hope you guys did too. Underneath them going back and forth, this was a pretty straightforward case. The restaurant owner didn't pay rent. I guess he tried to, didn't. There was some kind of incident that happened on the property, and the owner wants the land back or the restaurant back. That's simple. But it's fun to watch attorneys that don't like each other battle this out in court. I mean, it was. I don't know what the defense is gonna appeal. The owner didn't pay rent. He was late. It's in the contract. Sorry. Yeah. Anyways, let me know what you think. If you enjoyed it, please hit that like button. I would appreciate it. Until next time, bye.